The recent case of a nurse being removed from her profession has highlighted the issue of moonlighting, which employers sometimes have to deal with. The matter itself concerns Neelan Jaswal, a nurse from the Royal Orthopaedic Hospital in Birmingham, who was claiming sick pay for her absences from work when in fact she was working as a radio presenter on Voice Asia. She later admitted working for the radio station when a further complaint was received by the hospital. However, she claimed that her work for the station was part of her work for the church. When the hospital contacted the station, they found out she was contracted as a presenter at weekends and had also worked on weekdays. Upon further investigation, it was found that she had worked at the station whilst claiming sick pay for 35 days. The case did not reach the employment tribunal as the nurse quit the hospital in order to avoid being dismissed. She was, however, found guilty of dishonestly undertaking paid work whilst supposedly on sick leave and not declaring that she was working elsewhere. Undoubtedly, she would have been dismissed for gross misconduct, which would have been the correct decision. Ms. Jaswal may have struggled blaming God's work for her dishonesty and deception, hence her decision to resign before the inevitable. Even without the bogus sickness, her contract probably contained a clause prohibiting her to work elsewhere, or at least requesting authorisation for any other work outside of the hospital. Any breach of such a clause would usually result in dismissal. Employers should always use such clauses when they expect an employee not to hold other jobs, otherwise taking action against the employee may prove very difficult.